So my name is Richard Dissmann. I'm a partner in Bird & Bird in the German offices. In the Munich office, I'm doing soft IP litigation, and that includes in particular also copyright litigation. And I'm happy to talk about that with you today.
And I'm William Worley. I'm an associate from the London office, so working on soft IP matters, especially copyright, and I'm currently in Munich working with Richard and the team. And one of the great things that we get to talk about a lot is this interesting question of what is art and what counts for copyright purposes, and lots of very interesting cases that have come in from the German side and from the UK side in recent years. And I really wanted to talk to you about the recent Birkenstock decision, which I know you've been following closely. Maybe have a look at some interesting comparisons between the UK and Germany and how they're looking at these questions. Don't know if you want to give a quick introduction to what the case was about.
Yeah, very happy to do so. The Birkenstock case, I think, is one of the highlight cases of a subject matter of intellectual property that has been on the top of the minds of the IP lawyers for a number of years now, and it revolves around whether everyday objects like sandals or also chairs or lamps or whatever can be copyright protected as works of, as they say, applied art. And that has been a matter of debate for decades. It's nothing that has come about just recently, but it has been an issue of copyright law for as long as copyright law existed, probably. And while the standards for this copyright protection for works of applied art historically has always been rather high. And then, and we're going to talk about this, there had been some developments on the European level, 2 Court of Justice decisions of the CJEU, who sort of seemed to have shifted the landscape a bit. But then, everybody was wondering, what do they really mean? And now, recently, a couple of weeks ago, the German Federal Court of Justice, the Bundesgerichtshof, handed down a judgment on the Birkenstock sandals that most people know. And the ramifications of that is something we can definitely talk about.
Fantastic. It'd be really great if we could maybe go back, not quite to the beginning, because obviously copyright law is very old, but maybe to the starting point for this new development in copyright protection. As you mentioned, there were some CJEU cases, in particular the Kofemel decision and that line of decision making from the CJEU. And I was wondering if you could just explain a little bit about what that was about.
Absolutely. And we have to take one step further back, actually, in order to explain why these Court of Justice decisions were so disruptive in a way. The historic landscape in Europe was that copyright law was pretty much a matter of national law, and that every EU member state or every European country, including the UK, of course, had sort of their own idea about what copyright for works of applied art was all about and what the requirements were for protection. And the stance in Germany was, let's say, rather strict. I wouldn't say it was super strict. It was probably not the strictest, but it was definitely also not too liberal. And in very short words, the test was whether the design of a object, because that's what it's all about, was basically so outstanding that it went way beyond the usual, let's say, level of creativity that any other design would have. And the reasoning for that was very simple. As most people know, the copyright protection is very long. It's 70 years after the death of the author of the work. And assuming that the average author of a given work may still have to live 30 years, you can say by the rule of thumb, copyright exists for about 100 years. And that's a very long time. We're talking from today, we'll be talking about 2125. If you think about 1925 from today on, that was between world wars, it is a very long time ago, and certainly the world was a very different one than it is now. So 100 years is a mighty long time. So the German court said, well, copyright protection for everyday objects should be reserved to really outstanding designs, which, are so creative that they justify this long protection, because essentially the design protection, the regular design protection, is limited to 25 years max. Then EU copyright law was harmonized to some extent, and then in 2019 and 2020, 2 cases were brought to the Court of Justice from courts of the member states for preliminary rulings. And the Court of Justice came with formulas on those questions, which seem to be rather open and not so strict as the historic definitions were. And the Kofemel case, which was the first one decided in 2019, was basically on the design of some sportswear items, a pair of jeans and a sweater in particular. And for those who don't know, the Court of Justice of the EU does not actually decide the cases. The cases are referred to the Court of Justice by the courts of the member states for preliminary rulings on specific questions which may be decisive.
I think that's something that even some copyright practitioners can lose sight of, actually, when these decisions come down and they're very hotly debated. So it's really interesting you mentioned that.
Exactly. So the Cofimel case actually came from a court in Portugal. And one of the questions that the Court of Justice decided in Cofimel is that the definition of the term work is a EU law definition, and it should be the same throughout the entire EU. So the question, what was work, is an autonomous term of EU law. And they said that for works of applied art, no different standards should apply than for any other work type. So the standards should be the same for all work types. So far, so good. But then the Court of Justice still had to come up with a formula how to sort of test whether an everyday object was a work of applied art. And they came up with a formula which more or less said, well, a work would have to be an original. So that does not help too much yet. Then they said an original is if the personality of the author is embedded in the object through his free and creative choices. That was sort of the formula. And then everybody, jumped on it and said, hey, this is what we need now. We need free and creative choices. And that is, of course, something which sounds not so difficult to fulfill because, if you come up with something and you make some free and creative choices, that is quite easy to achieve. And the same was then sort of also repeated again in the Brompton case, which was handed down in 2020. So for the past 5 years or so, basically, everybody has really been wondering, what did the Court of Justice really mean when they said free and creative choices? And what did he mean with that the personality of the author must be reflected in the object?
Right. Yeah, no, it's really interesting. I mean, in the UK, we've obviously been following it very closely, notwithstanding that we're no longer in the EU. And certainly the Cofimel decision has caused a lot of interesting questions. Firstly, as you say, about the interpretation of the wording of the judgment, but also about the interaction with the UK statute, because, of course, we have the CDPA that governs which types of works can be protected by copyright. And in order to fulfill the criteria for protection, the object has to fit within one of the criteria that is set out. And the one that's most applicable to works of applied art is something called work of artistic craftsmanship. That's been a very vexed question. For a very long time, there was a judgment from the House of Lords in 1975, I believe, which set kind of the criteria. I'm doing scare quotes here for what a work of artistic craftsmanship could mean. It's been hotly contested about what the meaning of that decision was, but effectively there was a kind of belief that it would have to fulfill some additional criteria, and this was perceived to be in tension with Cofimel. We've had a couple of cases come down since then, which I'm going to come on to in a little bit. The first one was Response Clothing, another clothing-based decision in relation to a kind of wave pattern on the clothing, and the question was whether that could fulfill the criteria for protection. The judge in that instance kind of didn't feel that he needed to resolve the tension between Cofimel and the criteria for work of artistic craftsmanship, because he said it is a work of artistic craftsmanship, and so he felt that he didn't need to go into the details there. And then more recently, we've had the Waterborough case, which has brought in much more into sharp relief about how the court is going to look at these things going forward. But I'm sure we'll come on to that in a minute.
Yes, excited to hear about the Waterborough case, which, by the way, I have also been following a bit. And it's an exciting case as well. So maybe back to Germany. So as I said, after 2020, after the two Court of Justice decisions, everybody was sort of wondering, what about these free and creative choices? What does it mean? What about the personality of the author? Is it a natural consequence of the free and creative choices? Or is it rather that the focus is on the personality of the author that must be reflected in the work, and that is only achieved by free and creative choices naturally, because otherwise, the personality would be predominated by, for example, technical considerations. And because the Court of Justice only answers abstract questions, it was up to the courts of the member states to sort of fill these abstract formulas with life on real cases. Birkenstock was one of the first ones in Germany to take this ahead and claim copyright protection for their sandals, which most people know, and they've been around since the 1960s, essentially. And ever since then, Karl Birkenstock, or the Birkenstock Company, did not get the idea that they could be works of applied art. But after this Court of Justice case law, everybody sort of read the formula of the free and creative choices onto their products and said, hey, well, actually, we did make some free and creative choices here, so why shouldn't it be copyright protected? And the funny thing is that the Birkenstock brought a number of cases against a number of defendants because there are many, many Birkenstock copies in the market. And they started with some cases at the Court of Hamburg, and actually the Court of Appeal of Hamburg granted copyright for the Birkenstock sandal and says, yes, they were works of applied art. However, in other cases, Birkenstock chose the courts of Cologne. And the Court of Appeal of Cologne in 2023 decided that the very same shoes which had been considered copyright protected by the Court of Appeal of Hamburg were not copyright protected. So you had basically two conflicting Court of Appeal decisions of two courts who are on the same level.
Can I ask you a question about that? Because from a UK practitioner perspective, it's quite interesting, this idea about having lots of different courts coming, similar fact patterns and lots of different decisions. You've obviously got a lot of clients. I know you're not representing Birkenstock, so we won't ask about that necessarily. But is there a kind of logic or there's strategic benefits to going in one court or the other? I think for the UK audience, it would be interesting to know a little bit more about that.
Yeah, I mean, in Germany, as many people know, we have a federal system. We were a federal republic with many commercial centers. Historically, we've been a country that was at some point in history built out of many sort of little kingdoms, like the Kingdom of Bavaria and so on, Kingdom of Saxony. And the federal idea is still very much ingrained in the German culture. So we have different commercial centers like Munich or Frankfurt or Berlin and Hamburg and Cologne and so on. And so all these different regions have their own courts, and they basically go their separate ways until the Court of Appeal level. And only then we have the Federal Court of Justice, which is sort of like the umbrella court that resolves these disputes. And actually the choosing which of those courts to go to, if you have a choice, which you very often have in intellectual property matters, because you can essentially go to every court where the allegedly infringing item is sold. And that was the case in the Birkenstock cases. So that is called forum shopping. And it is a big part of what we do, is sort of thinking about which court might be the most suitable one, the best one, the most favorable one for any given case. And of course, we'll only find out when the decision is handed down whether our prediction was right. But yeah, it's what we think about a lot.
Of course. So you mentioned the federal court there. I was wondering if we come on to the federal decision in the Birkenstock case and how they chose to address this slightly vexed question of works of applied art and European law on that.
Yes, and it's very interesting. If you read it, the Federal Court of Justice, the Bundesgerichtshof, paid very close attention to aligning as closely as they could and wherever they could with the Coffermel and Brompton judgments. They cited them all over the place, but they somehow tried to bring them into alignment with a little bit of the historic German way to look at things. And what they did was very interesting. They said, well, actually, the focus is on the question whether the personality of the author is reflected in the work of applied art, in the original, in the object. And that is only the case if it is not a sort of everyday design, something that a designer would sort of create every day, but it is something which goes beyond that, which has like a sort of increased level of creativity. And I think the twist of the decision is that they found that in the German language version of the Brompton judgment, actually the word künstlerisch is used, which translates into artistic. And I've spoken to my friends who are fluent in French, and they told me that the French term créatif also has more like this artistic twist to it. It's just because creative, I think, is basically everything which is just, hey, I've made this up, it's my idea, so to speak. Right. And also, let's say, very regular ideas can be sort of creative. I understand that in English, creative can sometimes have even like sort of a pejorative twist.
Yeah, there's a little bit of that. If you were saying that an idea was a bad one, you might say, "Oh, that's a creative."
Exactly.
It's a bit like the word "interesting."
Yeah, exactly.
Not everything that's interesting.
I've heard the term creative accounting, so that is
yes, and of course it's quite a popular sort of reference to a job now, as people describe themselves as creatives. And that can be a wide range of different jobs. And obviously a lot of the people that we interact with in relation to IP are in the creative space. So it's interesting to hear that.
No, and I think there's also logic to that, because I always said from the beginning, after the Brompton and Coffermel judgments had been issued, a choice is always free, because otherwise it wouldn't be a choice. And if you would assume that the creativity is what you just described in the broader sense of having an idea, then, basically every choice or almost every choice also creative. So that cannot really be the test. And that's one of the difficulties with the European Court of Justice decisions, that they come in so many language versions. And I think this is a fine example where different language versions suggested different contents, actually. And I think the German court, what they did is they said, okay, we take the German version. Brompton speaks about artistic sort of surplus that the design must have. It must be artistic. And then they said basically, well, that's what we've always been saying for decades. It's actually in line with our history of thinking, and our line of thinking is in line with what the Court of Justice was saying, or at least meant to say, or at least said in the German version of the judgment, arguably also in the French version, which I think by default is the original version, if I'm not mistaken, of the Court of Justice judgments. And so they said, we don't know what all the trouble is about. We need something which is artistic, in the meaning of creative, as an artist. And they said, well, it's works of applied art. So what do you want? And basically said, we're not making anything new here. We're just basically filling it with life.
And how did they decide, without wanting to spoiler alert here, that Birkenstock sandals were found not to be a work of applied art? And how did they arrive at that decision?
They essentially said that it would have been the burden of proof would have been on Birkenstock to demonstrate that all these sort of free and creative choices had been made as an expression of the personality of the author. And apparently Birkenstock had not been able to provide that sort of conclusive evidence. The evidence submitted by the defendants rather suggested that Karl Birkenstock had been driven by technical considerations to make a good and healthy and robust sandal, which, if you look at the sandals, is something which doesn't seem totally unplausible.
I have a confession. I have at least one pair of Birkenstock at home. So, that's really interesting to hear you say that, because there are definite parallels with how the court, some of the rationale that the court looked at in the Water case, which, as you know, because we've discussed it previously, a water rower was a very attractive rowing machine that was created by somebody called Mr. Duke, and he sought to protect it through copyright. The defendant in that case was a company called Liking, or Topion, I believe. And the question was whether it could be a work of artistic craftsmanship. And in arriving at the decision that it was not a work of artistic craftsmanship, the court did decide to address this kind of head-on, what they saw as a sort of collision between the European standard and the UK standard. And interestingly, the court decided that it would have fulfilled the criteria for a work under the EU standard. However, when it went on to consider the additional criteria under the UK, whether it was a work of artistic craftsmanship, it said it failed that test. And in arriving at that decision, it looked again back to this Henscher case that I mentioned at the beginning, in particular to the judgment of Lord Kilbrandon, who said that the requirement was that a craftsman would need to have the desire to produce something of beauty, which have an artistic justification for its own existence. So this is the kind of differentiation between everyday objects and something a little bit further. And again, in arriving at that decision, they looked a little bit at Mr. Duke's intentions, including some evidence that he gave. They effectively said that the design was chosen by Duke as one of a number of ideas to achieve a business goal of creating a rowing machine with a sensory sort of element to the design, some sort of sensory benefit. But they didn't quite reach that standard of artistic nature that would require it to be chosen for copyright protection. So yeah, it was quite interesting that some of the same considerations, it feels like the courts are considering in both Germany and the UK.
Yeah, it's funny because I had also been following the Waterrow case actually for quite a while. And my personal take had always been that I would actually say, yeah, that might actually qualify for copyright protection because German and EU law, the element of beauty is not so relevant, beauty, as we all know, is possibly even more subjective than art. Yes. Different people find different things beautiful or not. And I thought that there was something in the Waterrower, but the German and the EU law does not require that sort of self-sufficiency, or that it says it needs to be like a piece of art in its own right. That is not required. That boils it down to the real core of the problem. The question, is the personality of the author reflected in the everyday object? That I think is just saying, is it art with different words? It's just a different way to phrase the very same question. You look at it and say, well, do I think that this really sort of reflects Karl Birkenstock's character. I don't know, maybe you would have to know his character or his personality. I think it will always remain a very subjective test in a way.
100%. And, the UK court went a little bit further in saying that it was necessary to avoid a kind of qualitative evaluation of what that artistic merit or quality was. I think there's some logical justification for that, because you don't necessarily need lawyers and judges making that evaluation. We have our opinions, as you say, it's very subjective. For me, it's always very interesting to look at the way the courts approach this, because deciding on the facts about whether somebody has intended to create something artistic, it's hard not to get drawn into some sort of analysis of whether it is in fact artistic or not. And I'm sure we're going to see more cases coming out dealing with this question.
And it's a very interesting one, because actually the question whether the subjective intentions to create art played a role were also subject of the Birkenstock case, but they're also subject of another pending referral to the Court of Justice of the European Union. There are actually two pending referrals which deal with the question or with the issue of works of applied art. One is a referral from Sweden on a table, essentially. It's called the Mio case in short. And the other case is from the Court of Düsseldorf. It's also about furniture. It's on the USM Haller office furniture system. Yeah. And one of the questions which is referred, or which has been referred to the Court of Justice there, is whether it does play a role what the author actually says that he thought when he created the object. And I think the decisions are going to be handed down sometime later this year. I still expect them for 2025 in any event. Well, my prediction is that the Court of Justice must say that the alleged subjective ideas and thoughts of the author do not play a role, because that would be too easy for the author in a litigation to come up with sort of saying, hey, when I created this, I thought this and I thought that. And then, of course, nobody would say, well, I didn't think of art. Everybody would come up with very detailed explanations how they wanted to create a great piece of art.
And there you get into some interesting sort of procedural considerations, because, as a UK lawyer, I would think, well, it's all well and good if an author turns up and says all of these things, but we've got quite an extensive disclosure process. We've got rounds of other evidence and expert evidence and things like that. And there are a lot of mechanisms by which you can get to what the intentions at the relevant time were. And obviously in different jurisdictions, it's a little bit different. So I'm sure that's going to play into people's sort of strategic calls later on as well.
Yeah, absolutely. And I wouldn't say that the design history does not play a role. I think it will play a role, but that's more than like a sort of objectivized way to look at it. I think that the real intention to create art, because art can be created at an instant, you don't have to necessarily work on a design for months or years in order to make it a work of art. I think Pablo Picasso was infamous for just sketching stuff on a piece of paper and then selling it for a couple of thousand euros or pesetas at the time. I don't know. But these are all super interesting questions. Another question referred to the Court of Justice at the moment is whether it does play any role if the object was then displayed in any design museums or even art museums or won any sort of awards, or whether it just basically has to be determined at the moment of the creation of the work, and everything that came afterwards does not play a role.
That's very interesting. I was wondering if I might just ask you what you think, how the Birkenstock decision will impact how rights holders and people who are creators, if it has any kind of major impact on the assessment that they make of their creative works and how they can protect them. I know in the UK, the Waterrow case is very interesting because it's the first time that a court has had to address this tension between these two areas. It was quite a fact-specific case, and it was at the Intellectual Property Enterprise Court, so our kind of very much first instance IP court. The judgment even refers to this as a question that may need to be resolved at the Court of Appeal level or above at some point. So I think, although it's very interesting, there will definitely be other fact patterns where decision may go a different way. I was wondering if you could share your thoughts on what this means for rights holders and indeed for users of works as well.
Yeah, I have some thoughts, but also have some hard experience from the past 5 years, because the Court of Justice decisions are 5 years old, essentially. And many clients, many right owners started creating much better record of the creation history, really documenting the design process, because they said, well, if we want to assert the copyright in those works at one point, all of this will be useful evidence. So a lot of care was taken to sort of create a paper trail of the creation of any design, whether it would then be copyright protected or not. But the perception at the beginning, after the two Court of Justice judgments in 2020, was that now copyright protection is super broad. It was sort of brought back, but many people now see Birkenstock as sort of something like in contrast or in conflict with the Court of Justice decisions. I don't see it that way. Of course, it sort of sets it a little bit straight and says, look, come on, guys, it's not that easy, But it also doesn't close the door on it at all. I've always said it from the first day. I think it hits the perfect balance, because it does say, well, it can be copyright protected if it is a work of applied art. And for that, there must just be something special to it, like this special twist where you just say, okay, this is something which really stands out a bit. It doesn't have to be a one in a million thing, but I think it really needs to stand out from the normal design quality, if you like. And many people say that this is something which the Court of Justice would have had to decide, but I think what the German Bundesgerichtshof did was just sort of read it out of the Court of Justice judgment and says it's all in there. The personality of the author is in there, the artistic level is there. So, they just analyzed it in, let's say, in a clearer way.
We'll be watching this space for the next cases that come down, including the EU referrals you meant to. And probably we could do another one in a year's time and there'll be more to talk about.
I'm sure, like with all these legal concepts which have open legal terms, which are a little bit vague, like bad faith or reputation. What does it mean? The IP lawyers always like to come up with formulas like it's a global appraisal of all circumstances of the case, which may not be too helpful for the academic to say, okay, now I know exactly what I have to do in order to analyze this. But this is our art. We are IP lawyers, so basically our art is having the experience and the judgment to look at something and just sort of feel it. I know it's very unsatisfactory for the academics to say, well, you have to feel it. But, at the end of the day, maybe that's what it boils down to.
That's it. Then the evidence, of course.
Yeah.
Very good. Great to talk to you, Richard.
Thanks, Will. Thanks for hosting the session. Let's talk again at some time about whatever comes up. And thanks for setting this up.
Brilliant. Thank you.